And he then goes on to describe what he saw. Also, the same sort of testimony you heard from his son saying Laquan McDonald was not threatening during this incident and really helping the prosecution's case here. I want to bring on two of my guests. Girley, he's on the phone, criminal defense attorney from Florida. And we still have Marni Snyder with us. Okay, let's talk a little bit about what's going to happen this afternoon, because we're expecting the defense to finally have their chance to put forth a case. And although to the common person, you know, the public that doesn't really know the ins and outs of the law, Jerry, this could be kind of like, well, they lied on the police report. Why shouldn't they be punished criminally? But it's not quite that simple.
Well, I don't know exactly what you mean when you say it's not that simple. It could be a matter of them talking about what their perceptions were.
Right.
And ultimately, you know, it is up to the trier of the fact to decide whether or not these were simple misperceptions or whether or not this was a concerted effort to actually submit false evidence to support their fellow officer who was obviously using excessive force and unnecessary force.
And their motivation for doing that is what a motivation really for any officer would be, just to protect one of their own. And these people, these officers, they all know each other. They become friendly, and they don't want another officer to get in trouble, I assume.
Well, yeah, I mean, that's understandable. I mean, I think all professions do that. You know, lawyers protect lawyers. Quite frankly, doctors protect doctors. However, how far do we take that? Now, we're talking about the ultimate issue here. Someone died a very violent death. So I understand this concept of the blue wall, but I think ultimately we have to get to justice. And therefore, the officers, certainly when they sign sworn statements, they have to tell the truth, or they face the same potential penalties as any other citizen if you lie under oath.
And Marni, Joe, what do you expect to see from the defense as we get into the afternoon here?
Right. Well, I think that we've said it, is that they're going to try to say that there wasn't the intent to cover anything up or to put false things there, but instead there was, you know, a mistake of fact. There was a misperception. Maybe even that there was a typo and paperwork problem that had nothing to do with any intent to mislead anyone.
That was a pretty big typo, Marni.
Right. Well, I mean, I've seen people say all sorts of insane things about their written statements, that they didn't look them over before they happened. I've seen police reports copied and pasted on a Word document before, so that each of the police officer statements is exactly the same, word for word, typo for typo. And so I believe that they're going to say that these people were shocked, that they were trying their best to comply with the investigation, and that there was no intent to mislead, which I don't buy, and we'll see whether the fact finder does.
Okay, Marni, stay with us. I know you have a few more minutes. We have to go to a quick break. We'll be back in just a few minutes. Welcome back, everybody, to the Law and Crime Trial Network. In just a few minutes, we are getting word that the Len Kachinsky case out of Wisconsin is expected to begin. In case you're just joining us, you might remember that name, Len Kachinsky, from that Making a Murder series that was so popular on Netflix. That's his mugshot. You didn't see him like that because he was actually the defense attorney of Brendan Dassey in the series. He came under a lot of scrutiny for how he handled that case. But this current criminal case that we're following, he's on the other side of the law. He's actually the defendant in this case. It's not related to making a murder. He's facing a felony stalking charge for allegedly harassing and stalking his clerk. You see, after he was a defense attorney, he went on to become a municipal court judge, and he had a clerk who claimed he sent her all sorts of creepy emails, and there was even an incident where he would just stare her down, she claims, and make cat noises. I would expect Marni Snyder, a criminal defense attorney, that this woman, this clerk, would take the stand in this trial.
Well, one, because she absolutely has to prove, or the prosecution has to prove, that there was emotional distress and that she suffered emotional distress for every element of this crime. So she's going to have to talk about that and recount how she felt afterwards. But obviously, crimes like this happen in private in as much as that the alleged stalker is creeping around. So she's probably going to have to testify to every incident. They also have to prove a course of conduct. So there's going to be multiple incidents that she's going to have to remember in front of the fact finders.
And it can't just be like, this guy's really, really creepy. It has to go beyond that.
Right. He has to kind of know or should have known that this person would suffer emotional distress, and he has to intend to cause that. Some of this behavior is incredibly creepy, but we have to see whether or not he should have known that this was going to cause incredible distress. I think a lot that's going to play into that is the dynamic. A municipal court judge and a clerk that works in that building, and in order to keep her job, needs to kind of survive whatever happens there.
All right, so if you are just joining us, the Len Kachinsky case, we just got word, I believe jury selection is completed and opening statements could begin in just a few minutes. If they begin, we'll break out of whatever we're in and take you to that courtroom in Wisconsin live to bring you those opening statements. So stay with us on that. For now, though, I want to turn back to that cover-up trial that we're covering out of Chicago, because we're expected to go live inside that courtroom as well this afternoon in order to really get you up to speed on what that case is about. Let's listen to some of the prosecution's opening statements. Take a listen. Okay, so that was a portion of the opening statements from the prosecution in the Jason Van Dyke case. I want to bring in my guest, Girley, criminal defense attorney, as well as Marni Snyder, who's been with me all morning. Let's talk a little bit about this, because obviously, different cases, same related case, but you really have a different audience in this case. One, the cover-up trial is a bench trial, and the Jason Van Dyke case was before a jury. How does that make a difference? And, Jerry, did you see a difference in the presentation by the prosecution?
Well, the prosecution was playing more to the emotions, I think, of the jury, making statements such as, what this officer saw was a black boy walking down the street who had the audacity to ignore a police officer. That is language that is directed toward the emotional response, or to engender an emotional reaction from the jury. And I think, quite frankly, it was very effective. Now, on the other hand, when you're having a bench trial in front of the judge, it's just the facts and the law. You can't put on a show, so to speak, for the judge. The judge is beyond all of that, so you're going to have an entirely different approach.
And wouldn't you say, Marni Jo, that judges kind of look down upon attorneys, especially during a bench trial, that try to get all theatrical and try to put on somewhat of a performance?
Somewhat. And I think that it is important, though, to show how important and serious the case was, in order to show that they needed to be careful with their police paperwork, and they should have known that. So I do think it's important that it comes across that this is a serious case, this is a disturbing case, because that helps establish motive. I think the theatrics would be the thing to play down, but not give up your record. I always try to make sure that during a bench trial, just because a judge might be rushing me along or trying to be efficient with their day, I don't give up any of those important things.
Absolutely. Okay, Marni Jo, I know you have to run, so we thank you so much for being here on the Law and Crime Network. Jerry's going to stick around for a little bit longer. We have to take a quick break, but we'll be back. We're monitoring a few live trials, and we'll take you inside the courtrooms when we return. All right, the defense attorney in the Len Kachinsky case really painting this as some kind of conspiracy by many people in the town to get Len Kachinsky off the bench. This really wasn't just this one woman accusing him of these things. Really quickly, Girley, you've been listening to these opening statements along with me. You're not there. I thought you were there for a minute, but it looks like that you are there. Jerry, are you there? Sorry about that. Okay, what do you make of those openings, especially what the defense is trying to say here?
it's troubling. I mean, I had trouble following it, and I think that openings should be simple. It should tell a story. It should be a preview of upcoming attractions, things that you expect that the evidence will show. It should not be your rant about who's out to get your client, because that's going to raise a red flag with the jury in most instances. So I'm concerned that the guy is wandering and meandering in his presentation, and there's nothing cohesive there, and certainly nothing persuasive.
Well,
so
this is going to be very interesting, because this isn't now just a case against Len Kachinsky. He is trying to say that this was some kind of broader conspiracy against him. We're going to continue to monitor this trial. We'll take you live back inside the courtroom. I'm signing off, but we'll be back in minutes.